if your investigator goes out and gets a statement from John Smith said all this happened, and then John Smith, you anticipate he's being called to trial, that does have to go to the prosecution.
Does the obligation to provide, for the defendant to provide copies of his expert reports and so forth, only go to those that he's going to use and offer?
Only that, yeah, because that's still, I would still argue that is work product material. If you don't anticipate calling that person in trial, that's probably the pivotal consideration of that. I still think that falls within privileged material. Okay? So,
but the old rule said it wasn't discoverable if you were going to offer a trial.
right, everything's got to go over now, and actually that's what we have here is Rule 16G with the expert reports. One thing here is very clear, the failure to disclose your report no later than 21 days prior to trial, and it's no longer a may term, but it's shall preclude the expert's testimony in trial. So it's got to go over if we anticipate calling that person. We've got to prepare written summaries of testimony, findings, analysis, conclusions, or opinion, and we have to include a summary of their qualifications. So again, if it's something to assist you in that, in your case, and you don't anticipate calling them, I think that's privileged material. If you're planning on using that person, it's going over.
But what if you're not? What if it's something that's detrimental to your case? You still have to provide that.
If it is something that's detrimental to your case, and that's part of, you're basing your strategy on that now. You're getting it in there, you're seeing it, that's part of your privilege, that's your product, your work product at that point. Okay, so I don't think that you're turning that over. There's nothing in here that says that you've got to turn something over. I mean, we have to advocate for our clients. I think ethically, we would be in some trouble if we're turning over everything as we're developing the case. Okay?
What if you had a case of an expert that didn't prepare a report?
You're going to have to.
Any expert's going to have to prepare a written report.
Your expert will not be able to testify as an expert. And therefore, if he's not at the scene and a lay witness is not able to stand unless that goes over 21 days before. So this rule really is a compromise to make sure that there is no Yeah, but, you know, and that's a good question, because I think that's one of those things that, as, remember I said at the onset of the presentation that, you know, there's things that people could get worried and say, this is going to, I think from a practical standpoint, this is really going to play itself out smoothly, and maybe some people will stamp it to err on the side of caution more at the start, but I think after we start to see that there's